I'm George Curtis. Welcome to It's Your Law. Each week it's my privilege to bring guests to you and to me that teach us about our law, how it's made, broken, enforced, and maybe how it should be enforced and made in a different way. This week I have a guest that's going to be talking about some things that are really in the newspapers every day. Drinking, marijuana, drugs, penalties, jail make up about 80% of our news, and it impacts probably 80% of our population. Today's guest is Matt Goldin.
Thanks, George.
Thanks for being here. Matt, you've been in practice here in Oshkosh for how many years?
It's been over 28 years.
Well, I remember when you came, and you and I looked a little younger then.
We did. It's been a good 28 years, though.
Oh, it's been great, and in your case, you've established quite a reputation, largely representing people who are accused of doing something wrong, and their freedoms are at stake, their privileges are at stake. Tell us a little bit about your career and education.
Well, I started my law career in Baltimore, Maryland, and went to law school in Maryland and took the Maryland bar, and ultimately ended back here in Wisconsin because that's where my family was. And rather than stick around in Baltimore, I thought this would be a little bit better place to live and raise a family, and that's ultimately what I did, and haven't regretted it, and operated a small practice here for quite a long time now. And really, we cater to it's a private practice, and lots of individual persons come to our office, and we represent them in a whole variety of issues. I would say the bulk of our practice is criminal defense, which would include impaired driving violations or allegations, drugs. There's just, with respect to impaired driving, there's just so many different aspects to it, and it seems like that's taken a lot of our practice in recent time.
What's the name of your firm?
It's Goldin and Lennon. Approximately 10 years ago, William Lennon joined me after he left the district attorney's office, and he's been there ever since. And he's a pleasure. He also works in criminal defense and does a variety of different other areas that he practices in.
You talk about the word impairment. What does that mean?
Well, impairment is, people often think that drunk driving means alcohol. And I guess drunk and alcohol go hand in hand, but it's really an impaired driving is what we're dealing with. The legislature and the law enforcement agencies look for impaired drivers when they're out. And impairment is really well beyond simply alcohol impairment. It can include drugs, prescriptive medications, and alcohol, or any combination. And it's illegal to drive if you are impaired. That's the bottom line.
And what's the definition of impaired?
That's a real good question. For alcohol, if you hit on your first, second, or third offense, if you're 0.08 or higher, there's a presumption of impairment. However, that doesn't mean you can't get an OWI or a drunk driving even if you're under the legal limit. It just makes it more difficult for the state to prove. Once you hit that 0.08 threshold, if you're a human being, and that's who I represent, if you're a human being and you hit that level, you are presumed impaired. You cannot be a human being and be above a 0.08 and not be impaired, or at least that's what the law implies.
Well, and what about all these people who are on medication prescribed by their physician that contain a narcotic? They're already a little impaired, and then how many drinks does it take for them to be real seriously impaired?
I don't have a specific number of drinks. I would say if you're even approaching, even having a question whether or not you should be driving or not, you should not be driving, because if you're impaired in any way, if you're, typically when a person gets an OWI, they get two tickets. They get the operating while impaired ticket, the OWI, and then they get a second ticket. It's called a prohibited alcohol concentration ticket. You will not get that ticket if you are under the PAC or under the 0.08. So you can get one, but then the prosecutor will not have the benefit of relying on the 0.08 violation to prove impairment. So he would have to prove that you were impaired by other ways. Maybe you had an accident. Maybe you ran off the road, maybe you were swerving. They can still prove it by what they call extrinsic evidence, but they cannot necessarily, they don't have a legal presumption that you're impaired unless you hit that .08 threshold.
Well, what about the refusal to take the test ticket?
My advice was always don't refuse, because if you refuse, typically what happens is there's a grid that they apply in this county and really almost any county I've been to in Wisconsin. And they classify the seriousness of the OWI by the level of your PAC, of your alcohol concentration. So the higher the alcohol concentration, the higher the penalty. And then if you refuse, they just lump you into the highest. So you get lumped into the highest category if you refuse to take the test. And under Wisconsin law, they can take the test anyway. They can just do a forced blood draw with a warrant, and I've seen that almost every time there's an arrest. They get a warrant. They're going to get your blood. You can either refuse and go in the highest category, or you can agree to it, and you won't necessarily get the highest category. In fact, you may get, it's possible if you're not impaired, maybe you'll come back under the .08. But even if you're under the legal limit and you refuse, that's technically a violation of the implied consent law. So then there's a whole separate bit of consequences for violation of the implied consent law.
And this subject of impairment seems to be getting more and more complex as new laws are passed, new drugs, new forbidden substances, and new ways to get high. We're going to have to take our first break. When we come back, that's where we'll begin again.
Sure.
We'll be right back. Welcome back to It's Your Law. I'm George Curtis. Matt Goldin is my guest. He's with Goldin and Lennon. They do criminal defense work. We're talking about impaired drivers. And we've already gotten the lesson that doesn't mean just that they've been drinking alcohol or too much of it. There are lots of ways of being impaired, aren't there?
There are. I mean, the biggest thing that I've seen recently is the THC law. Since they legalized THC and marijuana in Michigan, including for recreational use, and as of January 1st in Illinois, you see more and more THC-related impaired driving citations. And up until November of last year, if an individual has any trace of what they call delta-9 THC, which is the active ingredient in marijuana, any trace in their blood, they can get cited with a restricted controlled substance ticket, which is essentially another OWI. It's an OWI even if they don't even feel impaired. If they have any trace of that up until November of last year, that would be enough to support the impaired driving. Now that was recently changed in November to just like alcohol, there was a .08 threshold to create a legal presumption impairment. In November of last year, they created a threshold for marijuana as well, and that would be 0.1 nanograms in your blood.
How do you test for that?
The test for THC is always a blood test, and that's by statute. It has to be by blood, and there's an implied consent law in the state of Wisconsin, and if an officer requests that you submit to an evidentiary test of your blood after field sobriety test and a proper arrest, you're required to consent to that. Failure to consent would be a refusal, which has increased penalties.
Well, now, I do personal injury work, as you know, and I'm amazed with the cases that we handle, the percentage of people who are out on the street driving medicated, but they have a prescription from their doctor for the opioid. How do you test for that?
Well, if the alcohol, typically the first run of the test would be for alcohol. When they do a blood draw, they typically take 2 vials of blood, and they send them both to the Wisconsin Laboratory of Hygiene for testing. They test one, and they hold one. Typically, they'll hold one for the defense counsel if it wants to retest. But on the first one, they test for alcohol. If alcohol comes back above a .08, they stop testing, typically. And that's enough to potentially support the charge. If alcohol comes back at zeros, then they continue testing the blood for the presence of any all kinds of substances. They can test for cocaine, marijuana, all kinds of different substances. And if those substances, those illegal substances come back in your blood, that would also support the impaired driving charge that you have to defend against.
Well, is it illegal to be out on the road even though you haven't had any alcohol and you haven't had any marijuana, but you've just taken too many pills prescribed by your doctor for your neck pain?
You would be subject to an impaired driving citation. So yes, it would be illegal. If you're impaired to drive, you can't drive. And it's pretty subjective. That's why, I mean, you need to err, people need to err on the side of caution. Don't drive if you're taking any meds. A lot of meds do have warning signs, warning notices on the medications. I would heed those warnings, because if you get stopped and you're in the uncomfortable position where you're swerving, or if you have an accident or end up off the road, you don't anticipate having police contact, but next thing you know, you're doing field sobriety tests, you get arrested, and if they find those substances in your blood, you're in a lot of hot water.
Well, correct me if I'm wrong, but my understanding is now the law in Illinois allows recreational use of marijuana.
That's my understanding, yes.
And the same is the case in Michigan.
That's correct.
And in Canada.
Yep.
In Minnesota, it's a little different. It's medical use of marijuana.
That's right.
However, it's still illegal to bring marijuana into this state from any of those locations.
That's correct. And you can get all kinds of penalties on something that's completely legal in our neighboring states. And I see, it's kind of interesting. I was in court about 3 weeks ago, and my client had a marijuana possession charge. And ultimately, the district attorney's office, it was an Outagamie County case, was requesting 10 days in jail on something that's perfectly legal in other states. And for the first time, the prosecutor who recommended the 10 days was actually a different prosecutor who was in court. And the one in court acknowledged for the first time, they usually don't like to hear that it's legal in other places. Really what they care about, it's still illegal in Wisconsin. But the judge did consider that and gave a fine only. And the client was very happy, no jail time. And it seems the penalties in this particular state are just ridiculous. On small amounts of marijuana is misdemeanor. It's an unclassified misdemeanor. If you get a first-time marijuana charge, you're looking at 6 months maximum in jail and a $1,000 fine. People don't realize, though, if they have a prior conviction, criminal conviction for a drug charge, second time around they can charge a felony. And they're doing that. And they're still doing that, even with all the neighboring states, the legalization, which just makes no sense to me. And I see that more and more. So I think it is important that I think Wisconsin laws at least reflect, what the norm is. And I think the population supports legalization.
Well, it's a short trip to Illinois, even from people here in Oshkosh. And if I go to Illinois and I smoke marijuana in Illinois, that's legal, as long as I'm in Illinois.
That's right.
But if I bring any of that drug across the state line into Wisconsin, I'm now illegal.
That's right.
And no matter where I smoked it, if I drive while it's still in my system, that's illegal.
That's right.
Well, that's kind of a mess, isn't it?
It's a mess, and I think Wisconsin, the people of Wisconsin really stand in some jeopardy if they go to any of those other states and then return home. My advice is just don't do it. Don't drive if you're going to be using any of those substances which are illegal in Wisconsin.
Let's take our second break, and when we come back, I'll get some more advice from you, because this is really a complex situation in a state where we enjoy our recreation. We enjoy drinking. We're a drinking state, always have been, and the young people are using marijuana, and some of the older people too, and it has some medical benefits, so that it's actually prescribed by physicians. It's legal to some level in about 25 states, and Wisconsin is confused. I want you to straighten that out when we come back, Matt.
I'll try.
We'll be right back. Welcome back to It's Your Law. I'm George Curtis, and attorney Matt Goldin is my guest, and we've just posed a problem. The problem is the state of Wisconsin. In the state of Wisconsin, we drink a lot of alcohol. We smoke marijuana. We get medicines from our doctors. We drive. Any one or combination of those things make us impaired drivers, which is dangerous, causes accidents, kills people, maims people. I would think that some people have been working on solving this problem.
Well, Governor Walker, my understanding is he signed a law, a bill into law that allows low-dose CBD oil infused with THC Delta 9, but it's only allowed for children with seizure disorders. Very limited scope in the medical use. I'm not aware of anyone actually even using it or being prescribed that, or I don't know where they would even secure that medication from. But that's the very limited exception to the illegal threshold that where we're at today in Wisconsin.
It's a political football right now.
My understanding is the new governor is supportive of widening the scope of legal marijuana within the state. The Republican legislature is entirely against it.
Now, wherever there's sin, prohibited sin, there's money. People make money over producing and selling something that's prohibited. We should have learned that with prohibition back in the 20s and early 30s. We couldn't stop people from drinking. We just drove up the price by making it illegal. And the government tried another approach that I think is in effect right now, and that is make it legal but tax it. Would that work?
I'm good with that. I think it makes sense to legalize it. Certainly medical marijuana would make sense in the state, and I would say just legalize it like Illinois or Michigan, because it's going to happen. And the problem we have is so many people are incarcerated because of this. People don't think, many people in the population don't believe that a lot of our jails are filled with marijuana users, and there's a lot of people in there over THC and marijuana related issues. And it just doesn't make a lot of sense, the expense to society of incarcerating these people. Felonies, and when an individual gets a felony based upon a possession of marijuana, that felony is going to impact their ability to earn a living, to be productive member of society. Those expenses and costs associated with this illegal status really are not even considered.
Well, I think people should keep in mind, and I think you've made the point with respect to the drunk driving or impaired driving, that each subsequent offense has a very much increased and accelerated penalty.
Oh yeah, it's stepped up. I mean, it's first time. Wisconsin, by the way, is the only state. First offense is not criminal. So you can you could argue get away. It's not a getaway. It's a very substantial fine. It's still a loss of license, AODA requirements, but there's no mandatory, or there's no jail time and no probation available on a first offense. But on any other subsequent offenses are criminal, where there's minimum mandatory jail time. Second offense, I believe the minimum is 5 days, and it goes up from there. It can be very significant. On the guidelines in this county, that's what typically the judges in this county and all others look at. The minimum jail time on a second offense is 5 days. The minimum on a third offense is 45 days. Then you can only imagine where it goes from there. It goes up. And those are typically unaggravated circumstances.
Well, you've touched on my favorite subject, and that is incarceration and the cost of incarceration. Not just the cost to the taxpayers, not just the cost to the person who is incarcerated, but that person's family, dependents, the next generation, the school system, and the taxpayers.
It's huge. And I understand if an individual or a client ends up having to go to jail, it's never just that person who goes to jail. It's the whole family goes to jail with that person. It's a huge impact on an individual. And I mean, I think that our society really needs to make a decision. Are we going to be incarcerating people for marijuana possession? And I think many of our sister states have declined to do that, and they've changed their laws to to ensure that that doesn't happen. And I think Wisconsin, I don't use the substance, but I think that to be incarcerating people for simple possession of marijuana just makes zero sense.
Well, compare Wisconsin with Minnesota, where we have almost identical populations and very similar makeup of those populations, and we have twice as many people incarcerated as Minnesota. What's the explanation for that?
I don't have an explanation for that. It must be, all I can say is it's probably the way we prosecute cases and the guidelines. A lot of times there's guidelines that are given to judges with mandatory minimums. I am not a big advocate of mandatory minimum sentences because I think every case stands on its own merit. And then when you have a mandatory minimum, it really ties the judge's hands, and there's nothing they can do.
And of course, it costs money to have people locked up, as you pointed out, not just the person who was locked up, but his whole family and the next generation of people. The cost to taxpayers of this idea of lock them up, throw away the key, really hasn't benefited anybody, has it?
I don't recall ever seeing it change someone's habits simply for marijuana possession. And I just, I can certainly understand the incarceration and the punitive nature of OWI with repeated drunk driving. I mean, that's clearly a societal problem that needs to be dealt with. But I think that the penalties that are currently in place take that into consideration.
Well, Matt, our time is up, and I want to thank you so much for educating us on the complexity of driving while impaired and explaining to us that impaired is just impaired. You don't have to be stoned to be illegal. You don't have to be drunk to be illegal. And you don't have to be any of those things to be dangerous. I appreciate the work that you and your partner do. You keep fighting.
We will.
Thanks for being on the show.
Thanks for having me, George.
I want to thank attorney Matt Goldin of Goldin and Lennon for being on the show and giving us some information about a real problem in the state of Wisconsin. I have a great deal of respect for people who defend people who are accused of crimes. Disproportionately, these are poor people, and disproportionately, these lawyers don't get paid very much for their time, effort, and expertise. And remember the show we did a couple of weeks ago with District Attorney Mr. Gossett, who pointed out that locking people up isn't the answer. The longer we lock them up, the less chance they have of coming out and taking care of their responsibilities and not offending again. That's my opinion. I'm George Curtis.